Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations, within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to today's session of the Appeals Court, which is being conducted via Zoom hearing. The session will also be live streamed on YouTube. This is 19P 1276, AUNDREA Singleton versus the Boston Housing Authority. My name is Jeffrey Kinder. I'm joined by Justice Eric Neyman and Justice Edward McDonough. Counsel, we will proceed as if we were in the courtroom, so bear in mind that we have read your briefs carefully and your time is best served by getting to the heart of your argument. Each side will be allotted 15 minutes. As you know, there is no rebuttal, and you will see the time appearing on the screen. So with that, by way of introduction, I guess I should mention, if there is a technical problem of any kind and anyone drops out, we will temporarily suspend and then recontact you. But obviously, we hope that that's not necessary. So with that, let me turn to counsel for the plaintiff, Mr. Capilano.
Thank you. Good morning, Your Honors. Opposing counsel, may it please the court. I represent AUNDREA Singleton, the appellant. Your Honors have read the brief, so in short, you know that Ms. Singleton, who was severely disabled, had her housing benefit terminated in 2018 because her adult son, Brandon, was arrested for a deadly crime committed without her knowledge over 1.5 miles away from her premises. Brandon Singleton is currently serving 8 to 10 years in prison. The appellant is seeking to have this matter remanded to the BHA for proper consideration of relevant and mitigating circumstances that she did not have a chance to present, and for a lesser sanction than termination of Ms. Singleton's rights to public housing assistance. Your Honors, I wish to argue 2 points that improperly resulted in a decision to terminate her benefits. The first being that the hearing officer declined to recognize and even to exercise her discretion to even consider a lesser sanction than termination of Ms. Singleton's benefits.
Mr. Catalano, did the judge rule on that issue, whether or not a lesser sanction was raised and should have been considered?
Yes, Your Honor. There was the record appendix indicates that that was in fact considered, but something that wasn't given due consideration, I would argue, Your Honor, because of the fact that at the time of the hearing officer held the hearing, she determined that it was not within her realm to even consider a lesser sanction.
And what did the judge say about that?
The court said, 1 second, Your Honor. I believe, Your Honor, I'm sorry, I can't seem to find the citation to that specific argument by the housing court at this time. I apologize.
Okay, and as I understand it, you're framing this as a due process violation. So you're seeking a remand for the judge to consider, for the hearing examiner in the first instance to consider whether or not a lesser sanction would be appropriate. Is that correct?
That is correct, Your Honor.
So my follow-up is this. What if the hearing officer had said, I have considered the lesser sanction of taking the son off the lease or off the voucher, and I've considered all the relevant factors, and for the following reasons, I determined that the lesser sanction is inappropriate here. Would that have been a fair ruling or an appropriate ruling by the hearing examiner?
I think if she had expressly stated that she had considered it, that would be a fair ruling. What is not a fair ruling is to say that she didn't even consider it because it, quote unquote, it's not within her realm. In other words, not within her decision-making ability.
Well, counsel, forgive me. I think, doesn't that mean that she did consider it? When she said that she didn't believe it was in her realm, how is that not a consideration?
I think what that's saying, Your Honor, is that she doesn't have the discretion to consider it. Not within my realm suggests, I think, in common parlance, that it's not within her ability, not within her discretion, not within her jurisdiction, have you? All of which is not accurate, Your Honor. It, in fact, completely was within her discretion to have made such a determination. And the case law substantially supports that. Wojcik and Carter both substantiate that she must, in fact, consider a lesser sanction. Not that
well, if I may, you seem to be saying, and I don't mean to be flip, but that you always get a second bite at the apple. In other words, her son, she continued to keep him, as I understand it, on the lease after this murder. And you cast your argument in terms of due process, but what was wrong with the process? Like, you seem to be saying she violated due process just because she didn't agree. Was there anything wrong with the process itself?
I think the process, Your Honor, was abused by the hearing officer in that she said she didn't even have the discretion to consider removing him from the lease, which isn't true. I mean, she said it's not within my realm, which I equate to saying not within my discretion. Now, Ms. Singleton had kept her son on the lease. I'll remind the court that this was at the suggestion of the leasing officer. The leasing officer had said in response to Ms. Singleton's question, and this was within the termination hearing at Record Appendix 28, page 28, that she was told, Ms. Singleton, to leave it like it was. And then, Your Honors, to answer Justice Neyman's question earlier, it was on Record Appendix page 65 in the decision of the Housing Court, in which the Housing Court judge said the failure of the plaintiff to remove him from the lease if he was not being released from jail constituted something that she failed to do. But it wasn't a failure on her part. It was based on the fact that she twice asked if she could do so. First of the leasing officer, and again at the time of the termination hearing, when she asked the exact same thing of the hearing officer.
I'm not seeing that at RA 65 for what it's worth, but.
Oh, I'm sorry. The decision starts at RA 65. It's RA Record Appendix page 90. I apologize.
It's okay. RA 65 is the transcript, but okay.
Yeah, it is on page 90 of our Record Appendix, where she talks about the failure to remove the plaintiff from the lease as something that therefore did not warrant a lesser sanction or consideration of a lesser sanction. But I think, Your Honor, the case law is very clear that due process requires for this process to be done with integrity, for it to have been in accordance with jurisprudence under Carter and Wojcik. The hearing officer needs to have stated, needs to have recognized that imposing a lesser sanction, especially under the circumstances of this case. Ms. Singleton clearly had no knowledge of her son's involvement in the crime. She clearly didn't know anything about it. She certainly didn't participate in it, which frankly distinguishes it from even Carter and Wojcik. And
but counsel, if I may jump in, and again, I don't mean to be simplistic, but the argument you seem to be making is that the tenant would always win because you could have a violation because a family member committed violent criminal conduct, and then you could just always win just by saying, well, okay, I'll get rid of them. And how you're saying that they always have to accept that?
No, Your Honor. No, it's a balancing act. I think that all of the case law speaks to the issue that all of this needs to be balanced by the hearing officer. So it would be no more true to say that than to say that in every instance where there's a serious crime, that there is no need to consider a lesser sanction, which is simply not the case. The regulations speak to the fact that, in fact, they may consider a lesser sanction, even in circumstances where there's a violent crime. So, Your Honor, I think that neither one is exclusive, but it does require a balancing of all of the issues, including, which I would also like to get into, Your Honor, her disability. Which I can talk about that, Your Honors, unless you have more questions about the failure of the hearing officer to consider a lesser sanction.
But before you do, I just want to make sure I understand your argument, particularly in relation to Justice McDonough's last question. My understanding is you are not saying that the hearing officer would have had to accept the opportunity to impose a lesser sanction. It's merely that she had discretion to consider it. She indicated that she did not have such discretion because she said I would either uphold it or reverse it. She presented it as a binary choice and said, so that option, if you will, is not within my realm. So you are saying that she had to at least apply the correct standard, i.e. she had discretion to consider the lesser sanction. She didn't do so. So you're seeking a remand for her to do just that.
Exactly, Your Honor, because the regulation, specifically 24 CFR 982.552C21, specifically states that they must be aware of their discretion and exercise that discretion. It's not sufficient to say it's not within my realm. suggesting I don't have the ability, the opportunity to consider a lesser sanction. I think that was a complete mistake. And that alone, Your Honor, requires a remand so that that can be considered under the circumstances of this case. It wouldn't necessarily mean that the hearing officer would automatically determine that because she didn't commit the crime, that therefore this is an appropriate lesser sanction. But it's something to consider two-way in conjunction with all of the other potentially mitigating factors, including, of course, her disability. Which also,
Catalano, do you need to establish prejudice from her? If we assume that she was saying she lacked discretion to consider it, do you also have a burden to show some prejudice from that?
And I believe, Your Honor, the prejudice is that Ms. Singleton was, in fact, denied her Section 8 benefits, evicted from her apartment, and is now essentially homeless, but residing with her mother on her couch, which I know is not for consideration here. But I think there is extreme prejudice in that failure to even consider, because now, subject to that, the client lost her benefits entirely. She wasn't given an opportunity to remove him from the lease, to have any other lesser sanction that might have been available to her at the time, other than eviction.
Let me follow up on that question, counsel. Is there anything in the record that you can point to say that if she did exercise her discretion, that she would have imposed the lesser sanction?
Well, Your Honor, I can't point to anything necessarily in the record, but I think when you take into consideration all of the things that are in the record, meaning that she did not participate in the crime, it happened without her knowledge, she has a previously clean record, her son was arrested as of the time, incarcerated as of the time of the hearing, clearly wasn't going to be residing there anyway, that all those factors together might have been sufficient for a hearing officer to determine that perhaps under the circumstances of this particular case, something less than eviction would be warranted.
And you agree that I think you say in your brief that our scope of review is abuse of discretion, correct?
Yes, Your Honor, exactly. And abuse of discretion includes, of course, failing to exercise that discretion, which is what we argue occurred in this case. And then also, Your Honors, if I may, with the time remaining, with regard to her disability, now I can grant you that there was reference to her disability, both at the time of the termination hearing, and then again, there was reference to it both in the hearing officer's decision, record appendix page 94. But the reality is the hearing officer states she gave strong consideration to her disabilities, having not heard about them. Ms. Singleton, for what it's worth, doesn't have obvious disability. She was not in a wheelchair, for example. So for the hearing officer to have given strong considerations to disability she did not hear, meaning specifically her heart failure, her kidney disease, her lupus, her anemia, all of which requires medical treatment, means that there's nothing she could do.
Mr. Catalano, isn't it your client that has the burden of making, that is proving up the nature of the disability at the hearing?
Indeed, it is, Your Honor. And I think she was prepared to do that. But as I pointed out in our brief, Your Honor, she was more or less sidetracked, maybe inadvertently, by the question, tell me, Ms. Singleton, how is this connected to the crime? Well, Ms. Singleton, who was pro se, obviously couldn't make that connection and didn't understand why that question was being put to her. It was nonsensical to her for obvious reasons. The question is important when you're trying to assert a reasonable accommodation. And everybody, including opposing counsel in her brief, assumes that what Ms. Singleton was doing was trying to argue for a reasonable connection, reasonable accommodation, in which case a nexus or a connection between her disability and the crime would be necessary. That is not the case. In fact, the BHA administrative plan distinguishes making an argument for disability based on mitigating factors from reasonable accommodation. They're two different things, and they were kind of blended together incorrectly in a way that Ms. Singleton couldn't actually and appropriately and reasonably answer. And therefore, I argue it is not possible for the hearing officer to have given strong consideration to put on that scale to weigh against the seriousness of the crime in order to determine whether that truly was a mitigating factor. She spoke the words of it, but there was no evidence, no preponderance of the evidence, as is required, for her to come to that conclusion.
And remind me again what your offer of proof was in your brief as to what that evidence would have established.
The evidence would have established, Your Honor, and it's in our footnote in the brief, that first of all, she has congestive heart failure. She has polycystic kidney disease. She has lupus. She has anemia. And I might add that the hearing officer said, I may ask for more documentation if I need to, and then didn't exercise that discretion to find out more information about these specific disabilities. Had the hearing officer, I think, asked, tell me about your disabilities, then Ms. Singleton would have had the opportunity to tell her, as I've told you, what those disabilities are. She didn't. She went right to this question of, tell me how it's connected to the crime. Well, in this case, there's no way for that to have happened. Her disabilities had nothing to do with her son's commission of the violent crime. So she really couldn't answer it. I argue, Your Honor, in the circumstances of this case, where she was pro se, an additional consideration must be given to pro se litigants, as stated in the Carter decision, footnote 17. Because she was pro se, I argue it would have been important for the hearing officer to have asked at least a few more additional questions to tease out the nature of her disability, so she could make a legitimate determination as to whether or not that disability was outweighed by the crime itself.
Mr. Catalano, I have one final question, and again, I apologize, but I'm back to the issue of the sanction, the lesser sanction. At Record Appendix 94, the judge stated that the hearing officer took, quote, strong consideration of the mitigating circumstances and found that the mitigating factors are not sufficient to permit consideration of any other sanction. Why is that incorrect?
Well, again, with regard to strong disability, Your Honor, there was no evidence, obviously, as I've stated several times, to support the assertion that it was strong consideration. With regard to weigh against the seriousness, the reality is, Your Honor, all of this requires a balancing act. There must necessarily be an appropriate consideration of a preponderance of the evidence, meaning the evidence must be put forward, none of which happened under the circumstances of this case. And this, we argue, as in Carter, is contrary to jurisprudence and her due process rights to public housing.
Thank you, Mr. Catalano. I see your time is up. Ms. Marcolina, when you're ready, you may proceed.
Good morning, Your Honors. My name is Attorney Angela Marcolina, and together with Attorney Mike Lewis, we represent the Boston Housing Authority. Your Honors, I think it's important for the court, as a preface to this case, to understand, and I know the justices have read the briefs, that the Housing Authority sought termination in this case because the participant's son engaged in violent criminal activity. He participated in the beating and murder of another young man who lost his life. Yet we're not talking about that today. Counsel hasn't mentioned any of those details this morning. The activity took place less than 2 miles from the Section 8 unit. In fact, the violations in this case were for violent criminal activity and for a household member being engaged in other criminal activity that threatened the health, safety, and right to peaceful enjoyment of other residents in the immediate vicinity of the premises.
I think that's all clear from the record. So let's cut to the issue, which is—
Sure. So
let me start with this. Do you agree with your brother that the judge, that the hearing officer did have the discretion to consider lesser sanctions than termination of the voucher?
So the regulation that counsel cited says that the hearing officer may consider lesser sanctions.
Okay.
And I think that
now, I'm sorry to interrupt, but so
Sure.
Now moving to the transcript of the hearing,
yes.
the hearing officer stated, basically, I have to decide whether she goes or stays. And the lesser sanction that you're proposing is not in my realm. I'm paraphrasing, but isn't that essentially what she said?
I don't think it is, Your Honor.
Okay.
I think that counsel
that's
is taking this part of the hearing out of context. If the court looks back, record appendix,
Page 38, right?
I'm going back a little bit further to record appendix 26. Earlier in the hearing, she was asked if she had informed her leasing officer about what had occurred. And she indicates that she did not. And this is, at the time that the activity is committed. And then at the end of the hearing, she inquires again. And I think what the hearing officer is responding to is whether or not she is the one who practically would remove him. And she would not be the one practically removing him. That would have been something done with her leasing officer. So I also would point out that, the hearing officer does ask questions with regard to the son at Record Appendix 24. She asks at lines 20 through 22 about the time he's facing. I think that all of those questions point to the fact that she is considering whether or not a sanction short of termination may be appropriate. Can
you go to Record Appendix pages 37 and 38? There, the tenant says, I just want to know, like, if I was to take my son off the lease for him not to reside there, would I be able to keep my voucher?
Correct.
And it goes on, and the hearing officer says, the decision before me is whether or not I agree with the leased housing and moving forward with the proposed termination. Either I uphold it or I reverse it. So in terms of removing him off, that's something that's not within my realm. So from what I just read to you, it strikes me that the hearing officer is saying, I can't consider the lesser sanction.
Well,
how is that
again,
incorrect?
I would point to a little further up in that paragraph at line 5, where she prefaces the entire statement with, when you certify, right? She's talking about a process that participants undertake with their leasing officer, recertification. The court will note initially when she's discussing the conversation with her leasing officer, she didn't come in and voluntarily report that this activity took place. She didn't come in until there was a loss of income, excuse me, at which time she had to explain that this income was lost because he was incarcerated. Again,
Ms. Marcolina, let me interrupt with another question on that point. If we were to conclude that the hearing officer's statements regarding that not being within her realm reflect her view that she did not have the discretion, and I know you disagree with that.
yes.
If we were to conclude that from the transcript, would you agree that that is contrary to law?
I would disagree, Your Honor, because again, the regulations, if we're reading what the regulation says, it's a may, it's not a must. The hearing officer may, and in fact, what it reads is the PHA, the housing authority, may consider a sanction short of termination. So I don't agree with the logic that in every decision, in fact, I think it's contrary to common sense here, where the hearing officer is saying, I've considered all of the mitigating here, and because of the very serious nature of the violation, it's a natural progression then to understand that obviously there is no other sanction short of termination. So I don't think anything in the regulation says that the hearing officer has to say, I considered mitigating, this is what I decide on mitigating. And even though the mitigating isn't sufficient to outweigh the violations, I also have to say, but then I considered a sanction short of termination, which would be an opposite to the analysis that she's already done, which the housing court also agreed with. I believe the court's already pointed to RA 94, where the court says she considered the circumstances. She even characterized the disability as strong consideration. And she says that in light of the nature of the offense here, that the hearing officer's conclusion that termination was appropriate is free of legal error.
So you're saying that the hearing officer did consider effectively other sanctions and that they weren't appropriate here?
I think that she did. I think if the court looks at the questions she's asking with regard to the son and whether he's in jail and for how long, But Justice
Kinder's question was different. It was assume, hypothetically, assume that the hearing officer here did not consider lesser sanctions and believe that she did not have discretion to do so. Accepting that assumption, what then? Would you agree that there's a due process problem there?
I don't think there is. If at the end of her analysis of mitigating, the mitigating doesn't outweigh the violation. If she felt that the participants' mitigating circumstances outweighed the violation, then the next step would have been to consider that. But that isn't the conclusion that she arrived at. And the lower court agreed that the conclusion she arrived at was appropriate given the nature of the offense in this case.
Well, let me try, counsel. You quote the the regulation that said that the hearing officer may consider.
The housing authority, yes.
Forgive me, yeah, may
Yeah.
consider.
Yes.
But the judge seems to be saying, the hearing officer seemed to say, I may not do that.
I don't think that she is. I disagree with the position that she needs to say, I considered this, I considered that, I considered this, when in fact, point of fact here, she's saying, I weighed all of the mitigating. And at the end of that analysis, which I think the court should look at is as a two-step analysis here, these violations are so serious, her mitigating doesn't outweigh it. So the natural progression of that is termination, not then a sanction short of that, given what her analysis is on mitigating.
Can I ask a question taking you into the argument regarding disability?
Yes.
How could the hearing examiner adequately address the concept of disability without knowing something about the nature of the disability?
Sure. So with regard to that, I would point out again, the beginning of the hearing, the court will see that the hearing officer does read essentially what can be considered, including disability, as a mitigating circumstance. The hearing officer does ask a probing question to determine whether or not what the plaintiff, in this case, what the participant was requesting, whether it was a reasonable accommodation. I do think that beyond that, the hearing officer probing for information regarding someone's diagnosis, regarding the nature of their disability, would be an opposite to guidance that HUD has given housing authorities.
Are you saying that the hearing examiner could not have asked the question, ma'am, what is the nature of your disability?
I don't think she could. Under the HUD DOJ guidance from May 17th, 2004, a housing authority is, even in the context of a reasonable accommodation, not supposed to be asking questions about the nature of a disability, the diagnosis, treatment, details, any of that. With regard to mitigating, she certainly could have provided that information. The hearing officer does ask her at the end if she has documents that she wishes to submit. She says she does not. I do want to point out to the court, though, with regard to that, when the court reviews this record and looks at what was argued below, this is an argument that's appearing here at the appeals court for the very first time. In fact, counsel has argued that the thought that this could have been a reasonable accommodation is preposterous. However, that's precisely what counsel argued below. And the judge indicated in the decision with regard to that argument that, in fact, when looking at counsel's complaint, that she didn't plead that. She didn't plead anything related to disability. And so this argument really isn't even properly before the court because it's appearing for the first time here at the appeals court. What was argued is that this was a missed reasonable accommodation. And the court disagreed with that. The court looked at what the hearing officer asked with regard to the testimony on disability and said that the hearing officer had done what she was required to do. Furthermore, I'm not sure what prejudice counsel is pointing to, because the hearing officer concludes that she's considered that, she's given great weight to that, even without further details. I'm confused as to how counsel can characterize the hearing officer's conclusions as insufficient because he doesn't believe that she had enough information.
Well, perhaps it's because there was no evidence at all regarding the nature of the disability, which would make it difficult to analyze or evaluate the impact that disability would have on termination.
I understand that. I would say it is the participant's burden to present that information. She was allowed, the opportunity to do that at hearing. The hearing notice, which is in the record, indicates that she can bring all of that information, that she can request a reasonable accommodation. She's then informed that again at the beginning of the hearing, and she was asked for documents if she wanted to submit them, and she didn't choose to share any of that very private information at the time of the hearing. In fact, again, these diagnoses are again only making their way to light here in front of the appeals court. They weren't raised in front of the lower court, and they weren't raised in front of the hearing officer.
And to what extent do we consider, if at all, the fact that she was pro se in this proceeding?
She was pro se at the initial administrative hearing, but she was represented by counsel at the housing court. She was not pro se. And so able counsel represented her, drafted a complaint, and argued this case. In fact, again, this case was sent back on remand to the hearing officer twice because the crux of their arguments, which are not before the appeals court today, were about sufficiency of evidence and immediate vicinity. They didn't raise these issues. And again, counsel raising this mitigating issue related to her disability really isn't properly before the court because it's never been argued before.
Counsel, are you saying that the argument that the judge failed, that the hearing officer failed to consider a lesser sanction, that was not raised in the housing court as well? No,
that argument it was raised in the complaint. It certainly wasn't an argument that was vehemently made. Again, the crux of the two issues in this case were not issues before this court today. And the lower court did remand this case twice for the hearing officer to extrapolate on the issues that were being argued and at the forefront of this case.
Did the remand have anything to do with the hearing officer's decision not to consider a lesser sanction?
No.
And do you believe the judge in her decision addressed that issue?
I believe she did. She did.
Can you refresh me on that?
Sure. At 94, the judge, and once before, she does indicate, this is an argument that has been raised. She says that she found that the hearing officer took strong consideration of mitigating circumstances and found that the mitigating factors are not sufficient to permit consideration of any other sanction. In light of the nature of the offense, and even if the hearing officer was only considering the assault, in light of the holdings in Melendez, the court cannot find legal error.
Counsel, thank you very much. Unless there are further questions from either Justice Neyman or Justice McDonough, I see none. Therefore, the hearing is concluded and the case is submitted. Thank you.
And we are live.
And you have an opening call. Good morning, ladies and gentlemen. This is Jeffrey Kinder. Welcome to this morning's session of the Appeals Court via Zoom. I'm joined by Justice Eric Neyman and Justice Edward McDonough. The case on the docket this morning at the moment is 19P0580, John Doe 97428 versus the Sex Offender Registry Board. Counsel, I will remind you that this is an impounded case, so please bear that in mind during the course of your argument. As you know, we have read your briefs carefully in the relevant portions of the record, so we would encourage you to get to the heart of your argument, to use your time wisely. Also, as you know, each of you has 15 minutes. There is no rebuttal. With that, let me turn to counsel for John Doe. Mr. Campbell, you may proceed.
Thank you, Your Honor. Brandon Campbell for John Doe. I would like to proceed to the first argument in my brief. I think that the fundamental problem here is the hearing examiner's handling of the expert testimony is incorrect under Doe 23656. This was a case that was issued by the SJC last September. Obviously, the examiner did not have the benefit of that case, but a hearing examiner is required to listen to a petitioner's expert evidence. And I am aware that a hearing examiner is not required to believe that expert, but neither can the expert reject or neither can an examiner reject expert evidence without a proper basis and at a minimum, a proper explanation in the record. And what is problematic with the examiner's handling of the expert evidence, there are two things. If you look at the page record appendix 30, the hearing examiner's treatment of Dr. Plowd's testimony and the handling of the actuarial evidence, which I'll talk about that a little more in a sec, but the hearing examiner says, I consider that these instruments, that's in reference to the actuarial tests, do not take into account all of the factors considered by the board and do not address the board's collateral inquiry of dangerousness. Therefore, I give the doctor's risk opinion minimal consideration. There's two problems there, the treatment of the actuarial and then just a blanket giving minimal consideration to the uncontroverted expert testimony in this case. So the problem in the recent SJC case that I just mentioned, it was a similar situation. It was in the context of a SDP case. The petitioner presented expert testimony, and I'm sorry, it was a SORP case. The hearing examiner discounted the expert's risk opinion because the expert didn't offer any opinion on dangerousness. Okay.
Let me interrupt with a question. On that particular case, didn't the SJC reaffirm that the hearing examiner was free to reject the testimony of the hearing examiner, even though there was no contrary expert testimony?
Yes, but I don't, what the court went on to find, it's true that the court didn't reverse the, basically what the court said in that particular case is even though there was that problematic language in the decision, overall the hearing examiner got it right and considered everything. But I think in this particular case, we have it explicitly in the hearing examiner's decision that the hearing examiner is discounting these actuarials because they don't address dangerousness. And I agree, they don't address dangerousness. They're not supposed to address dangerousness, but they're highly probative of the risk of reoffense.
The other thing that the judge seemed to emphasize, the hearing examiner emphasized, was the 16-year history of repeated and compulsive sexual assaults on young boys. That was a fair consideration, was it not?
Absolutely, it was a fair consideration. And if we were only talking about the appropriate level of dissemination and the dangerousness inquiries, I might not be making this argument. But the science as to risk of reoffense, which is a critical element, one of three that the board is required to prove by clear and convincing evidence. The actual evidence on that count was, I would argue, greatly in favor of the petitioner. But it's not that it was my particular opinion on the strength of that evidence. But did the hearing examiner reject it without a proper basis? And I think she did. She says in the opinion that she doesn't give this a lot of weight because it doesn't address dangerousness. Well, it wasn't intended to address dangerousness. This is evidence that is based on empirically validated risk assessment. It reflected put Doe in a cohort of approximately 92% of people who do not reoffend. That was highly probative of the risk element. And if the hearing examiner wants to say, I don't I don't accept the static 99R results in this particular case because perhaps the instrument isn't good for these types of offenses, or the petitioner doesn't fit in the cohort that the test was normed on. Some reasonable explanation, then I wouldn't be making this argument. But to say that it doesn't apply to dangerousness, therefore I don't give it very much weight. I think that is clear error under 23656.
Judge Wilkins seemed to take or express some concern, as you have, in the hearing examiner's findings, particularly his rejection of the expert testimony. But in the end, after expressing concern about that and the lack of appellate guidance, he came back to the additional evidence and found that the hearing examiner had described adequately and addressed the expert's testimony. Why was he wrong about that?
I think, Your Honor, because of not only just what I said, but the hearing examiner also claimed to give Dr. Plowd's testimony minimal consideration. And I am hard pressed to understand why uncontroverted expert testimony that is presented by the board, we have a live testimony of an expert who's presenting the most up-to-date research. It isn't seriously contradicted by the board. There was a short 4 pages of cross-examination. Why that would be given minimal consideration. And I think it goes to a fundamental misunderstanding by this hearing examiners and others in cases I've seen where it's almost like they feel like they're threatened by expert testimony, and it's up to them to try and trash is too strong a word, but to discount an expert even when their credibility isn't being challenged, because it somehow infringes on their sphere of decision making. And I believe that a hearing examiner should be giving full consideration to these experts when they're not being challenged by opposing expert testimony. And by the way, just because the board has a policy of never presenting any expert evidence doesn't make their burden any lighter. I mean, they are still required to prove all 3 elements by clear and convincing evidence. And
Mr. Campbell, let me ask you, if we were to adopt your position, if you persuade us, doesn't that essentially mean that the board would be required to, in any case where there was an opposing expert, hire their own expert?
Would they be required? No.
They would never prevail, however, if they did not.
I don't believe that would be true either. Even, I believe it was the 23656 case, the court noted that there were actually, the hearing examiner had a basis to question the expert's credibility because he had forgotten having done an evaluation on the offender many years before. So, many petitioners go in on my side of the V without experts, and they argue on the basis of the scientific literature. And SORB is certainly free to make those arguments based on scientific literature. Would that put them at a slight disadvantage? Perhaps in some cases, but these are decisions about risk, and they are grounded in scientific evidence. And if they are not putting up experts, that should be to their peril.
Counsel, if I may, can't a jury, a judge, or a hearing officer find an expert to be credible, but just come to the bottom line that the expert is just not persuasive? I don't think we necessarily need to say reject or find not credible. Just it's ultimately, is the expert successful in persuading? Isn't that within the prerogative of anybody hearing expert testimony?
Doe has a right as part of judicial review to have these findings, these written findings. That's part of it. There's a due process requirement of written findings. And those written findings must explain the hearing examiner's reasoning. And I don't think it's sufficient for a hearing examiner to say, nah, I just don't buy it. I think if that were the standard, it would make judicial review of these cases just untenable.
But Mr. Campbell, following up on Justice McDonough's question, and didn't the hearing examiner go further here? And by that, I mean this. You started your presentation by quoting from a portion of Record Appendix page 30. In the prior paragraph, the hearing examiner wrote that, like the doctor, I've considered, and he delineates various factors that the doctor considered, and then states, however, I have also weighed the petitioner's repetitive and compulsive offending over 16 years, and he discusses contact and non-contact offenses. By using the word however, it seems that the hearing examiner is stating that he considered a number of factors or focused on factors that the expert did not.
I don't think it is possible that in the hearing examiner's mind that she went through the proper analysis, but I don't think that we can tell that from these findings. I think with respect to her treatment of the actuarials, linking them, discrediting them for not speaking to dangerousness, giving Dr. Plowd's testimony minimal consideration. I don't think that these findings demonstrate that this hearing examiner performed the proper analysis. And again, she did not have the benefit of DOE 23656 at the time of this hearing, but this case did issue while this appeal was pending, and DOE should have the benefit of that case.
Anything you want to add about your privilege argument?
Your Honor, I recognize that my brother has cited Commonwealth v. Lamb. I concede that that is negative authority for my side. Doe did undergo an examination by an expert and was given a Lamb warning. I'm arguing that this court should draw a distinction from Lamb based on fairness and public policy considerations. Nowhere in the underlying case do I see that there was a knowing and voluntary waiver. Although I will concede that there was a deposition, there was testimony in the underlying federal SDP case. I don't see that there was a waiver. And I will also, with respect to this individual case, I will note that 4 years ago, I brought this issue to a panel of this court, and the panel did not address the issue. It remanded it because DOE 380.
I see your time has expired. Thank you very much.
I rest on my brief. Thank you.
Thank you. Mr. Shinai, when you're ready, you may proceed.
Thank you. Do you want me to wait for the timer to come up?
Yes,
Oh,
there it is.
Good morning, Your Honors. David Shinai for the board. And I think Mr. Attorney Campbell's right. He and I have been dealing with this case for a long time. Recently, on May 14th, the Supreme Judicial Court issued DOE 234076, which again reiterated that a hearing examiner is expected to give consideration to an expert's evidence and opinion if that expert testifies, but doesn't have to accept it.
I'm sorry, Mr. Shinai. Can you give me that case name again?
It's 234076. And the court in that case, again, reiterated that a hearing examiner is not obligated to accept uncontroverted expert evidence. If a hearing examiner decides not to, that hearing examiner has to explain why, and there should be a basis in the record to support the hearing examiner's decision on that. In this case, the hearing examiner was clear. She agreed with much of what Dr. Ploud was saying, but did not agree on the final risk opinion, which was he felt that the positives in this case reduced him to a level 2. The hearing examiner found that the same positives that he expressed, she agreed with, but she didn't believe that it actually reduced his risk. And she said why? Because of his history, 16 years of abusing boys throughout many countries in the world. The fact that I'm sorry, I lost my train of thought. And that these boys that he was sexually assaulting were between the ages of 8 and 13. And that not only that, he had been convicted in a country, Budapest, Hungary, and was convicted and incarcerated for that, for sexually abusing boys, and still continued after his release to sexually abuse boys. When he left the United States with this case, his federal case pending, not only did he go to Mexico, but he started accumulating massive amounts of child pornography involving boys. And some of the paraphilia that was involved with this case was also concerning. I think what's really important is that Dr. Ploud says that this individual doesn't presently have improper thoughts about boys, doesn't have any of the issues of pedophilia, but he says pedophilia is not curable. And more importantly, when he says these things, Dr. Ploud's findings are based on this individual's self-reporting in the SVR20. And what's also interesting is the SVR20 is a sexual violence index. It's not designed to actually determine sexual recidivism. It's designed to determine, is somebody a risk for sexual violence? Why he used that actuarial tool is not really clear, but it really isn't applicable here because no one has said that this individual is a sexually violent individual. He's someone who, if he does reoffend, is going to reoffend against boys between the age of 8 and 13. So there was a basis in the record for the hearing examiner to not agree with the final assessment, with the risk assessment. Dr. Ploud saying that this individual is a moderate risk and level, and the hearing examiner saying, no, the positives don't bring him down to that level. He's still at this point at a high risk and a high danger, and therefore made him a level 3.
Mr. Shania, what do you think we should make of Judge Wilkins, the portion of Judge Wilkins' decision that sort of outlines the fact that he is troubled by a hearing examiner being entitled to make these decisions regarding risk of recidivism without any supporting expert analysis?
Well, again, Judge Wilkins has his opinion, but in the end, he did agree that there was enough here in the hearing examiner's analysis to support her final decision not to accept the level 2. Much of what Judge Wilkins, in both in the original case and then in the remand of the case, much of his dicta is around trying to get the hearing examiners to flesh out more information. But in the end, he did agree in this case that the hearing examiner had reached that level. He believes barely, of course, the board believes a little more strongly than barely, but that fact should be sufficient at this point, and his analysis should be sufficient and supported because the hearing examiner did go through the steps necessary to determine whether or not the risk assessment made by Dr. Ploud was valid and whether it was based on information in the record. Again, the hearing examiner does agree with much of what he says. She just does not agree that those positives that he focuses on reduces him below a high risk and a high danger. I think that's essentially the center of this case. And based on that, on that issue, unless there's any questions, the board would rest.
It did strike me that the number of mitigating factors here were certainly higher in volume than we see in many of these cases. And it struck me that Judge Wilkins was relying on that to some extent. Do you agree with my assessment that the volume of mitigating factors was high in this case?
In this case, it was high. The problem is the individual's behavior, especially around his sexual offending behavior, his mental abnormality of pedophilia, unfortunately outweighed that. If this was just a situation where an individual 15 years ago committed indecent assault and battery, had got all of these positives that this individual had, that would have been a different result. But you're talking about a type of sex offending behavior that puts it beyond right now at that point of the hearing. It hadn't started to reduce, these positives hadn't started reducing that issue. And, you know, this is one of those cases where we may find on a reclassification that things have changed. But right at that point, at the time of the hearing examiner felt that the type of sex offending behavior, the history of this individual over and how many children were involved in this case over his career, that these positives hadn't yet brought that risk down, especially because Dr. Ploud said he suffers from pedophilia and it's not curable. And he has had clearly times when he wasn't involved in this type of behavior because he was incarcerated at one point. But when he got out, he began it all over again. So based on that, I think the hearing examiner's analysis of that issue was proper. I agree that when you have high levels of positives, in most cases, it would have an impact. This is a specific type of case with specific facts that are not only concerning, but have high levels of risk and danger involved in them.
Thank you. Unless there are further questions, and seeing none, the case is.
Patricia, I'm having difficulty getting the, for some reason, the all photos on. I only have a.
And we are live.
Good morning and welcome to today's session of the Appeals Court. My name is Jeffrey Kinder and I am joined by my co-panelists, Justice Eric Neyman and Justice Edward McDonough. This case is 19P0852 James STVIL versus Brian ARRIGO and others. Counsel, as you know, we have read your briefs and the relevant portions of the record carefully. So we encourage you to get to the heart of your argument. Each side will be given 15 minutes. As you know, there is no rebuttal. And from time to time, we may interject questions as the case proceeds. With that, let me turn to counsel for the appellant. You may proceed when you're ready.
Thank you, Your Honor. Ira Zalesnik for the appellant city council of the city of Revere. There are many issues raised in this appeal, but I'd like to go straight to the issue that I would suggest to the panel is the most important and is dispositive of this appeal, which was the trial judge's misallocation of the burden of proof. The trial judge in his decisions erroneously shifted the burden to the city council to establish that the standards for the issuance of a special permit had not been met. That burden properly belonged to the plaintiff and should have been put on the plaintiff. So for example, with the issue pertaining to the odor and fumes of the paint and the paint booth, it should have been the plaintiff's burden to establish that the remaining 2% of the emissions were de minimis, not the burden on the city council to establish that in fact the remaining emissions posed a substantial detriment to the community. I think this is aptly illustrated by recent events with scientists trying to determine the fatality rate of the COVID-19 virus. if they don't have a denominator as to the number of cases, they cannot establish what the rate is. And here, all we know is that 98% of the fumes are purportedly captured by the paint booth. We don't know anything about the remaining 2%. And as in the fish case, which I would suggest to the panel is dispositive, we don't know what the impact of that remaining 2% is. It could be a danger to public health. It could be a public nuisance. We simply don't know because we don't know what the total universe is. And indeed, the remaining 2% could be very significant. And it was certainly—
Mr. Zalesnik, didn't the plaintiff present expert testimony that I believe Judge Wilson credited?
Well, first, Your Honor, if you go back to the transcript, the judge refused to credit Mr. Friedman as an expert and said that he was delivering testimony strictly as a fact witness. And if you go back to that portion of the transcript, you can see many of my objections to opinions that were being elicited were sustained. So that's the first point. The other aspect of that is that, and if you look at his testimony before the city council at the second meeting, and I believe that's at page 303 of volume 2 of the record appendix, the testimony of Mr. Friedman was that he didn't know what the impact of the fumes would be because it was paint related, and he only dealt with the booth. He didn't deal with paint, and I'm paraphrasing to some extent, but that's the essence of his testimony. Was I don't do paint. I do paint. I do the booth, and so there's really no way, even if you credit his testimony completely, there's no way of determining what the impact of the remaining paint fumes and emissions out into the air are. I would also like to direct the panel's attention to the aerial photograph of the locus, which I would suggest to the panel is very important, and that's located in the exhibits volume 2 at page 18. And that photograph shows the garage building, and immediately there are two streets. One is labeled side streets off Broadway. One is labeled Folsom. The one to the north of Folsom Street is Rose. That is not labeled on the aerial, but that's an important block between Folsom and Rose. And there are, in close proximity to this garage, approximately a dozen homes right there. And there are a couple of homes on Folsom Street that are directly behind the garage. So we have no way of knowing, given that proximity, what the impact of the emissions may be. And that's a critical point. The garage itself is located in a general business district, but that general business district is a narrow strip that goes right along Broadway. And then immediately behind it is all residential area.
I think those facts are very clear from the record. So that's, since you have limited time, I'd like you to address the Wendy's case issue. And my first question for you is, my understanding is that the city learned it at the trial that the prior use of the property was such that the classification as garage commercial was in error. Is that correct?
Well, I learned it at the trial. I brought it to the attention of the building commissioner after trial.
Let me stop you right there.
Yeah.
Was there any sort of motion, post-trial motion filed with the judge, like a Rule 60B motion or something, so that that issue could be addressed in the first instance by the trial judge as opposed to by the city on remand?
No. At that point, it was already had been remanded to the council. I don't believe that at that point the special assignment had been made. So we did not know at that point.
But a Rule 60B motion would go back to the trial judge in the first instance. And it would seem to make sense. You understand why I'm asking this question, right? The judge had made a decision, at least in part, based upon his understanding of the classification of the property. Wouldn't it have made sense to go back to the trial judge in the first instance to say, there's a mistake here, judge, whether it's a mutual mistake or whatever the basis is, and give the trial judge an opportunity to address it in the first instance?
Well, I would take responsibility for that, Your Honor. That would be on my watch, and surely it would have been, it might have been better, but again, this was a process that took place over an extended period of time, largely because I'm not as familiar with the zoning code as the building commissioner is. And when I ordered the transcript of the testimony, I got it back, I looked at it, it just didn't seem right to me. So then I presented the transcript to the building commissioner, and he said, you know, you're right, this is really a commercial garage storage parking use, not a commercial garage, which is more auto repair and motor vehicle repair.
So why does Wendy's not apply? The judge did make findings of fact, and as I understand Wendy's, when the judge makes those findings, the city is bound by, the parties are bound by them on remand in this type of context.
Yeah, I would suggest to the panel that the Wendy's is not applicable because the classification issue is not a finding of fact, it's an issue of law. And this was, as Your Honor indicated,
But wasn't there a stipulation that indicated that as a matter of fact, or regardless of whether it's a matter of fact or law, that the parties accepted this and proceeded accordingly?
There was not a stipulation as such, Your Honor, because
there's a stipulation that the building building inspector accepted the prior testimony and representations of another individual who characterized it as such, right?
No, what happened was, Your Honor, is that apparently in sitting down between plaintiff's counsel and the building commissioner at the very beginning of the process, the building commissioner said to the plaintiff's counsel, what's the use? And the use is, they said, a commercial garage. And so it went from the step number one at the very beginning of the entire process. It went to the, it went through the process, site plan review committee, city council, zoning committee, all the way as a change in use from a commercial garage to the special garage. And so that was just the, and I would suggest it was a mutual mistake. That was the understanding of the parties at that time. And I would also point out that the officials didn't necessarily know what was going on at that garage because it had, according to Mr. Anzoni's testimony, ceased doing business as such back a number of years before the application. So it wasn't like this was an ongoing business and they could see what was going on. This was requiring some kind of institutional knowledge that they simply didn't have. Ordinarily, I would, I would not be arguing so strenuously for the reclassification, except that it is a zoning issue. And this Commonwealth gives particular importance to the citizenry of having the zoning ordinances and zoning bylaws enforced according to their terms. So this is not simply something that was an inadvertent stipulation or a stipulation improvidently entered into. This was a mistake as to zoning, which should indeed be able to be corrected by the courts. Now, I understand that I understand very well Judge Wilson's discomfort with the fact of having gone through a trial with the parties understanding that the zoning was as a commercial garage as opposed to the special garage. But again, even the unfortunate aspect of this should not override the Commonwealth's important interest in having zoning laws enforced.
Well, that actually leads to the issue of judicial estoppel. And I saw you cite the Otis case, which discusses that perhaps judicial estoppel might not be, we should be reticent to apply it when there is something like a mutual mistake that's made in good faith. But Otis goes on also to say that strict application of the doctrine might not be called for if the new inconsistent position is the product of information neither known nor readily available. Why is it that this information wasn't readily available to the city council? It seems with just a minimum of diligence, someone in the city, through the years that this case has been ongoing, should have been able to ascertain what the prior non-conforming use was that led to the existing classification. And I think that may be a hurdle for you, but you can correct me if I'm wrong.
No, Your Honor, I think it's a hurdle, but it's the situation with all mistakes. I certainly think that I should have ferreted this out before the case went to trial. I didn't. It was presented to the city council initially as a change in use from a commercial garage to a special garage. In hindsight, it's always easy to look back and say, well, they should have known. But the fact is they didn't. There was no.
The issue isn't should have known. It's whether it was readily available, right?
Well, but I think the judicial estoppel doctrine is looked upon in the decisions as being not so mechanically applied, so that these factors are, as I say, mechanical as opposed to being a part of the weighing of the equities. And I would suggest here that the parties simply didn't realize what was going on.
Your time is up. I'm sorry to interrupt, Justice Kinder, but Justice Kinder's about to tell you that your time has expired. If I may, Justice Kinder, I have one final question.
Certainly, go ahead.
Thank you. Is the judge's determination on judicial estoppel reviewed for abuse of discretion?
I would suggest not, Your Honor. It's a question of law, and it would be reviewed on a standard of whether or not that was applied in error. I would also point out that I believe on June 2nd, there was another unpublished opinion of this court, which applied the doctrine of judicial estoppel in the manner in which I was talking about. And I would, by post-argument letter, I'd like permission just to cite that particular case. I don't have the name off the top of my head.
Very well, your argument is complete. Thank you. Mr. Rabia, when you're prepared, you may proceed. As soon as we have a clock up there.
Thank you. Mike Rabia on behalf of the appellee, James STVIL. I just want to address his name very quickly. It's first listed in the pleadings as STVIL, S-T-V-I-L, but he is a Haitian immigrant and it's really STVIL. Just the periods got dropped. He's a
Thank
Haitian immigrant who's been operating as a businessman in the Revere area since 2004. I'd like to begin with just a bit of scene setting. The auto body shop that has been authorized by the special permit, although not yet acted upon, is not being plopped down into the middle of a residential neighborhood. It's on Broadway in Revere, which is a state highway number 99. And the record shows clearly that there are numerous auto-related businesses in the immediate vicinity, including 3 auto body repair shops. If you look at the record appendix, the second volume of the record appendix, page 325, there's testimony from a resident about 3 auto body repair shops in the area. There's also a trial testimony from Officer Christopher Giannino of the Revere Police Department's traffic division head. This is at transcript page 138. And there's also the trial testimony of civil engineer Peter Blaisdell at transcript pages 247 and 48. So this is not some kind of interloper auto body repair shop that he proposes to put in the neighborhood. It actually, fits into the neighborhood, notwithstanding that there are residences, in the vicinity. I'd like to begin sort of with where you left off, which is the doctrine of judicial estoppel and why the city is both bound by that doctrine and by the Wendy's case in Judge Wilson's determination as to the prior use. First, in its briefs, the council is correct that as a general matter, a municipality cannot be estopped, but that's by actions of its zoning officers. But that's different from judicial estoppel. When a city maintains a position in before a court, it can be judicially estopped. And I'm going to cite 2 cases, one from the appeals court. This is it's a Rule 128 decision, Lunenburg versus Gallagher-Aleva. It's 2008. The Westlaw citation is 2008 WL 3455830. And then there's also a land court decision, O'Brien Homes Incorporated versus Town of Lunenburg, 2018 WL 2340796. So the
Counsel, if I may, counsel, on that point, isn't judicial estoppel more typically applied where a party takes a legal position as opposed to a factual situation where there may have been a mistake?
I don't think so. I mean, as my brother counsel, admitted, Judge Wilson would be miffed, to say the least, to know that he spent a trial based on an assumption to which the town agreed. And by the way, it was a stipulation before at trial. It was an exhibit at trial by the building inspector. It's at Record Appendix Volume 1, page 15. There's an actual stipulation by the town, and the Special Permit Review Committee of the city of Revere also agreed that its prior use was as a commercial garage. So I think it is usually stopped. And then there's also the question of, this is a fact found by the judge. So I think Wendy's does control here. And on the issue of the prior use, I would respectfully suggest that all the hullabaloo in the city council's briefs amount to there's no there there. They claim that as Judge Wilson puts it, the comparator should be changed from commercial garage to parking facility or parking storage facility, but they make no hay out of that. There's nothing to suggest that initial determination had any bearing on the 4 major impacts cited in the first city council decision. If you recall, in its first decision, the city council denied a special permit application, citing 4 impacts: parking, traffic, noise, and odors. And contrary to my brother's representation, Mr. STVIL did offer affirmative evidence on all of those points. I agree that there is wording in the language of the trial court decision, trial court judgment, that may suggest a misallocation of the burden of proof, but that's because Judge Wilson was responding to how the decision was written. In that decision, the city council affirmatively said that there was a substantially detrimental impact, and he rejected that decision. But the main point is, Mr. STVIL did carry his burden onto those 4 impacts. And with respect to parking, traffic, noise, there's nothing whatsoever in the appellant's briefs that indicates any of those findings were clearly erroneous. Although, in fact, there's nothing about noise at all in the second city council denial. They do rely on parking and traffic impacts, but it's the same movie all over again. We have expert testimony from Kenneth Cram, who was an expert at the trial, as to the limited parking and traffic impacts from the proposed garage. And with respect to traffic, let me stress that Mr. Cram actually began from a 0 baseline. It's as though he began as if there were no business there whatsoever and counted and quantified the traffic impacts. He found, I believe it was 14 additional vehicle trips in the morning and 19 at night. And given the volume of traffic on Broadway, it's a de minimis impact.
Mr. Rabia, I have 2 questions for you.
Yes.
First, getting back to judicial estoppel, what do we do with the case law, the Otis case and the other cases cited, which essentially say that judges should be reticent to apply judicial estoppel in situations like this, where there is a mutual mistake, which this judge stated at least was not made in bad faith?
I don't think there was a mutual mistake here. I think the sole basis for the town's, I'm sorry, for the council.
The language, sorry, I misspoke. The language is mistake, not mutual mistake. So
again, I question the premise. The council's sole basis for saying that it was actually not a commercial garage before is the testimony of Tom Sanzoni, one of the family members of the family that ran that business for going back to 1925, and his testimony there was very clear on the fact that there were substantial repair activities going on in that garage. So it may have been that the usage of the garage diminished somewhat over time. In fact, that if you look at the affidavit of Richard Anzoni, who worked at the facility for nearly, I believe it's 40 years. I'd have to look at his affidavit to be sure. It went down from 2 full-time mechanics to 1 full-time impact, but there were definitely.
Since this is a summary judgment case, why don't you assume, for purposes of the question, that there's a question of fact as to whether there was a mistake? So, with that in mind, why is this a case where it's appropriate to apply judicial estoppel?
I'm going to rely on your discussion of Otis case and questioning my brother, which is that the information as to its prior use was readily available. In fact, in trial testimony, Officer Giannino talks about coming across the buses in his operation and in his activities as the head of the traffic division. So it was readily available to the town. This is not the case of Mr. STVIL pulling the wool over its eyes. So based on that, I don't think the reticence that may be appropriate should be applied here.
Okay, and my second question is, although in Wendy's, I believe the SJC said that was an appropriate case for the judge not only to remand, but to essentially order a permit to be issued or order a certain classification or what have you. It's pretty rare in which situation in which we authorize judges to do that, or in which judges are authorized, better said, to do that. Why should we do that here? I understand the timing issue. It's been a long road, but isn't it better for the judge to reconsider, or rather for the city to reconsider the application for the special permit under the correct standard in the first instance?
Well, again, I'm going to answer your question, but again, I want to stress that we think the correct standard was applied, that it actually the prior use was as a commercial garage. But setting that aside, I think Judge Wilson's decision on summary judgment, was very clear that he did not order the issuance of a special permit lightly. He understood that this is something to be rarely done, but he thought under the circumstances, given that on remand, the city council basically ran the same movie again and came up with the same decision. The only new thing it added as grounds was the allegedly flagrant disregard, for public safety. And by the way, the record contains an affidavit from Mr. STVIL saying that despite receiving notices, the city has never operated to shut them down or to enforce any of these this allegedly flagrant disregard for public safety. But even if there were disregard for public safety, as Judge Wilson properly found, that's not a zoning related concern. That's not what a special permit granting authority looks at when it determines whether or not a special permit should be issued. So given that the City Council's second bite of the apple was the same as the first bite of the apple, and I think it was appropriate in this case. It's one of the rare cases where it was appropriate to order the issuance of a special permit. So I think so this appeal, it's not about denying the special permit based on traffic impacts or parking impacts or noise impacts. The allegedly flagrant disregard for public safety cannot justify the denial of this special permit. There's no grounds for changing the comparator from commercial garage to some sort of parking or storage facility. And even if you look at the definition of commercial parking and storage facility, I'm not even sure it would fit into that definition either, because it refers, if I can find it. Bear with me just one second. I got to find the record. Well, it refers to parking that's not accessory to a principal use, but the vehicles that were housed overnight in that facility were being used regularly primarily for school buses during the past three decades. So I don't think it would even qualify under that definition if the City Council wanted to recharacterize it. And what we're left with is where Mr. Zalesnik began, which is the issue of odors. And there, what we have here is not just a finding that 98% of the smokestack of the paint emissions would be captured, and that's not purportedly captured. That's uncontroverted, unrefuted testimony from Mr. Friedman, but that they would be dissipated, 20 feet in the air. I understand the case law talks about severity of impact is to be assessed, by the special permit granting authority, and there's some deference to be shown. But under the circumstances, especially when you have 3 other auto body shops in the area, you have to wonder why this one application for a special permit for an auto body shop, is being denied. It's consistent with use in the area, and I think what we're talking about is really de minimis impacts. I mean, if it were simply the case that a special permit granting authority had unfettered discretion to assess the severity of impact, someone could justify denying a restaurant a special permit because of odors emanating from that. I mean, I would think that, there are certain people who would be more annoyed by restaurant odors than by paint fumes, where it's 2% of the particulate dissipated, 20 feet into the air. So again, I don't think there was a misallocation of burden of proof. I think Mr. STVIL met his burden of proof and showed that he was entitled to the special permit. And I ask that this court affirm the judgment of Judge Wilson from the court below. And I have a minute left. I can answer other questions, but I believe at this point, I'm happy to rest of my papers.
Questions from either Justice Neyman or Justice McDonough?
Thank you both.
Seeing none, thank you very much for your argument. That was very helpful. The case is now submitted.